Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. This is probably going to be my last live for today unless something pop off before we start celebrating the holidays. So, to all those celebrating today, Feliz Navidad and happy holidays. Merry Christmas Eve. All right, so we got to hop on into this new update in the Megan the Stallion case versus Milagro Gramz. She's a YouTuber that has been, uh, well, I want to say accused, but Megan ended up filing a lawsuit against her for defamation, cyberstalking, intentional infliction of emotional distress, as well as the deep fake video. And so they have been going back and forth. Milagro, she ended up filing a motion to dismiss, but then Megan ended up filing an amended complaint with all of the things that I just mentioned. And then on top of that, Milagro has decided to file a motion to dismiss the first amended complaint. Now, mind you, the last motion, it was denied because Megan, her attorneys ended up stating, because it was actually a motion to dismiss for failure to state a claim. And the judge went ahead and denied that order. And now Milagros is coming back with another motion to dismiss the first amended complaint. And that's what we're about to tap into right now. So let's hop on to that. Okay. So here we have her motion to dismiss the first amended complaint. And here is, I'm gonna go through this. I'm gonna go through this very, very quickly without interruptions. All right. Here's the intro. And this is, I'm assuming that this attorney for Milagro is really, really trying to plead this case in order for this to get dismissed. But ma'am, you did what you did, so you now have to suffer the consequences. But let's hop on into it. So they provided a quote stating, "Let me never fall into the vulgar mistake of dreaming that I am persecuted whenever I am contradicted." Quote by Ralph Waldo Emerson. So plaintiff Megan Pete, a well-known celebrity in the hip-hop universe, known for her sexually explicit lyrics and who goes by the moniker Megan the Stallion, filed the instant action against defendant, an online personality, social media blogger who regularly live streams and posts about current topics, including celebrities and the hip hop community. In her original complaint, plaintiff attempted to assert statutory claims under Florida laws, plus tort claims of intentional infliction of emotional distress and invasion of privacy. With a dismissal of her original complaint hanging over her like the swords of Damocles, plaintiff has changed her strategy course by attempting to manufacture a defamation action against the defendant in her First Amendment complaint, originating primarily from defendant's coverage and commentary regarding the public criminal trial of celebrity rapper Daystar Peterson, aka Tory Lanez. Rather than rebuke the commentary or debate the issues raised by defendants' comments so people can make up their own minds, plaintiff has succumbed to a current trend of using the legal system in attempt to cancel those opinions she disagrees with. Plaintiff is also attempting to revive her statutory claims under the Florida statute section 836.13 and section 784.0485, as well as her dubious claim of intentional infliction of emotional distress. While the First Amendment complaint, well, let me see, make interesting reading by media and so media followers, it too fails to present clear and convincing evidence to plausibly state a viable cause of action in tort and a plausible statutory violation under federal law. Therefore, for the rightfully request that plaintiff's first amended complaint be dismissed. I have to totally disagree with that. I think that amended complaint was very specific as to how um she was defamed, how they used the fake video, how she was cyber stalked, all the 9 yards. So I don't see this one being even granted. All right, so let's see. The first thing that says count one fails to state a claim for defamation. So they're saying that she didn't state her reason as to why, or a valid claim as to why or how she was defamed and why should she seek defamation damages. So it says, having abandoned her attempt to bring a claim for invasion of privacy, a legal theory not recognized in Florida for over 15 years. Plaintiff now attempts to bring a claim for defamation per se against the defendant based on various statements made by defendant on various online platforms. In this diversity in action, the substantive law of Florida applies to plaintiff's defamation claims as well as her other tort and statutory claims. So it says defendant submits that count one of the amended complaint should be dismissed for two reasons. One, the plaintiff failure to provide defendant with pre-suit notice per Florida statute. And two, plaintiff's failure to allege a plausible claim of defamation against a public figure. Defendant will address each one in turn. Now, I thought that Megan Thee Stallion did reach out to her and ask them to stop, I don't know, stop talking about her, something along those lines. But I'm not sure if it was actually like a demand letter. I don't know. Plaintiff failure to comply with the requirements of Florida Statute 770.101 requires that count one be dismissed. So let's see what they're talking about. So under this statute, it says before any civil action is brought for publication or broadcast in a newspaper, periodical, or other medium of a libel or slander, the plaintiff shall at least 5 days before insinuating such action serve notice in writing on the defendant specifying the article or broadcast and the statements therein which he or she alleges to be false and defamatory. Here, the plaintiff has failed to comply with the condition precedent under Florida law prior to the filing of the defamation action against defendant. Oh, all right. So if she didn't do that, ugh. So if she hasn't sent any type of demand letter and stating, what comments she considered was defamatory as required by the statute of Florida, I don't know about this one. And this is just count one. Lord, all right. So the law in Florida says you got to let them know, but 5 days where you file a lawsuit, you have to put them on notice on what acts were defamatory. This makes sense now. Blah 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 blah. Let me see. It says they cited Cummins and Canvaris. Also Jews for Jesus Inc. versus Rap. All right, it says blogger with YouTube channel was entitled to pre-suit notice under 770.01 and affirming dismissal of defamation action. Ooh. So they actually cited cases similar to this one where the plaintiff has failed to notify the defendant prior to even filing the lawsuit. God darn it, Megan. This one says fails to allege a plausible claim for defamation of a public figure as a matter of law. So in this instant case, plaintiff's defamation claim is predicated on the following allegations. One, that the defendant published and falsely accused Miss Pete of a crime of perjury by questioning her credibility as a witness in a high-profile criminal trial. Two, defendant called plaintiff slow and retarded and questioned her mental competency. 3, defendant published false statements that suggested that Miss Pete was an alcoholic by calling Miss Pete a drunkie and stating that drinking ran in her family. All right, because these are claims that Megan did put in her amended complaint. I'm just making sure that y'all okay. I'm just and my internet connection is probably going in and out. That's why I'm gonna make this quick. So those are the three things that Megan did state in her amended complaint that she deemed as defamatory. Like these statements were false. Um, the defense attorney advised that when these actual statements are reviewed in their full context, rather than in a hypersensitive safe space echo chamber, it is clear that the multiple allegations of quote unquote defamation are in overreach, as these statements are not susceptible to defamatory meaning in the mind of a reasonable person. What? As such, plaintiff's defamation claim should be dismissed for the following reasons. 1, none of the statements complain state or suggest that plaintiff committed the crime of perjury. 2, the statements made by defendant are substantially true. 3, the statements made by defendant in their full context establish that they are clearly opinion and or rhetorical hyperbole and therefore not actionable as a matter of law. Further, the plaintiff has failed to establish malice by clear and convincing evidence as required by the First Amendment and the law of Florida. So what y'all try to say is Milagro got free speech and she can say whatever she wants to say, and this is not considered defamatory. All right. Plaintiff deliberate decision to cherry pick statements outside of their context, as well as her promulgation of self-serving and overreaching innuendos regarding these statements, failed to bring her claim into the realm of plausibility. To help assist the court in the determination of this motion, the defendant has filed full and complete transcripts of the relevant recordings and actual online Twitter posts specifically referenced in the amended complaint. So, what they're saying is that Megan took what, how can I say this? She took bits and pieces instead of looking at everything in whole or the thing in entirely. This is like when I was saying about drawing conclusions. Like you can't draw conclusions based on a sentence, right? You have to read the whole paragraph or the whole book for that matter. So what they're saying is that Megan is just taking little bits and pieces out of either YouTube videos or Twitter posts and she's drawing her own conclusions. But Milagro is trying to say that Megan has taken those out of context. And so what they did was they provided the whole transcript of her YouTube videos for everybody to read through to understand the context. And this is only to make it seem as if this girl did not sit here and defame Megan. I'm confused. That's crazy. I'm gonna post the transcripts for y'all. Y'all can even go to Milagro Gramz YouTube page and look at the transcript. But this is crazy. When reviewing the complained what? When reviewing the complaint of statements in the proper context, it is evidently clear that the plaintiff wholly failed to allege a plausible claim for defamation against a public figure as a matter of law. That's crazy. In order to set a cause of action for defamation against a public figure, a plaintiff must show publication, falsity, and the actor acted with knowledge or reckless disregard as to falsity on a matter, actual damages. The statement is defamatory. This is crazy. A written or verbal publication, such as one on social media platforms, will rise to the level of libel and slander per se only if, when considered alone and without innuendo, it charges a person has committed an infamous crime charges a person with having an infectious disease. 3, tends to subject one to hatred, distrust, ridicule, contempt, and disgrace. And I think that it covered this one based off of what she was putting out. Tends to injure one in her trade or profession. The statement should not be interpreted in the extreme, but as a common mind would understand it. So they're just saying that Megan just blew everything that Milagro said out of proportion. That is what? I think everybody has seen how this girl acted. You know, it is one thing to read words on a document, but to actually see somebody's reaction, their body language, that says something uh that's something totally different. I like to see like if you're going to do this, what Kimmy said, Megan left out parts of I understand that. I do understand that, but the way that this lady was carrying on, like you can read transcripts all day. However, I think everybody, and yes, everybody is entitled to their opinion, but it does go like I don't know. They will show you what Megan left out. Okay, gotcha. All right. So all right, and where the court finds that the communication could not possibly have defamatory or harmful effect, the court is justified in dismissing the complaint for failure to state a cause of action. All right. Moreover, a defamation plaintiff must provide evidence identifying allegedly defamatory statements with sufficient particularity. Additionally, a court must consider all the words used, not merely a particular phrase's sentence. All right, so I see where this is going. Attention should also be given to any cautionary terms used by the publisher in identifying the statement. Oh, my mama would be calling me. Let's see. It is for the court to decide whether the complaint of words are actionable expressions of fact or non-actionable express of pure and or rhetorical hyperbole. Okay, and they're citing Florida cases. Here we go. In determining whether an allegedly defamatory statement is an expression of fact or an expression of pure opinion and or hyperbole, context is paramount. In which I do agree with that. I do agree. Let me see. All right, and they cited, let me see what this citation is. The test to be applied in determining whether an allegedly statement constitutes an actionable statement of court, examine the statement in its total. Okay, that I do agree with. That I do agree with. So if you did leave out bits and uh portions of like the whole text, then I understand where they're coming from. A statement is considered a rhetorical hyperbole when the language itself negates the impression that the writer was seriously maintaining the plaintiff committed the particular act forming the basis of defamation. Although rhetorical hyperbolic statements may at first ooh, that thunder sound bad. Although rhetorical hyperbolic statements may at first blush appear to be factual, they cannot reasonably be interpreted as stating actual facts about their target. In determining whether an allegedly defamatory statement is an expression of fact or an expression of rhetorical hyperbole, context is paramount. All of these circumstances surrounding the public must be considered, including the medium by which it is disseminated and the audience to which it was published. Let me see. As noted by the court in Corsten and versus Colangio, it states where an issue is controversial, evoking strongly held views, statements relating thereto are more likely to be deemed rhetorical hyperbole. Ha. Holding that statements by an NBA team owner who referred to player as opposing team who committed a hard foul against one of his players as a thug, and a newspaper sports columnist referring to the same player as a gangster and a wankster were examples of hyperbole and not defamatory. Oh my gosh, Lord. All right. They cited Old Dominican Branch versus Austin, where it stated that a strong disagreement between union members and opponents of unionization supported finding that challenge statements were protected. In Hay versus the Independent newspaper, they cited that affirmed dismissal of libel action brought by a private person who was called a crook and a criminal in a letter to the editor as statements were pure opinion. All right, this is interesting. Finally, with respect to a public figure, it is paramount that they establish actual malice. Actual malice requires that a plaintiff plead and ultimately establish that the defendant acted with the knowledge that it was false or with reckless disregard of whether it was false or not, and must be shown by clear and convincing evidence, not mere speculation and belief. Thus, defendant's 12b6 argument on this point requires plaintiff to plead allegations that allow the court to reasonably infer that defendant actually entertained serious doubts as the veracity of the published account or was highly aware that the account was probably false. Malice in this context refers to the truth, not the plaintiff. This standard is extremely high. Let me see. As noted by the Supreme Court in Hustler Magazine Inc. versus Swalwell, it stated in the world of debate about public affairs, many things are done with motives that are less than admirable are protected by the First Amendment. When a speaker or writer is motivated by hatred or ill will, his expression was protected by First Amendment. Thus, while such a bad motive may be deemed controlling for purposes of tort liability and other areas of law, we think that the First Amendment prohibits such a result in the area of public debate about public figures. Man, that was deep. Y'all probably don't understand, but that was actually deep. That was actually deep. So by her calling her slow, by her saying that she has a drinking problem. I forgot whatever the third cause was. It was more of a rhetorical hyperbole versus being defamatory. And she may not like it. She's not going to like it. But that is Milagro Gramz' right to speak on that. I mean, she I'll be rooting for Megan. But I mean, they make a very good argument right here. This is a very good argument, and they cited some really good cases. Let's see what they talk about. Two says, as noted recently in media, the trial of Canadian rapper Tory Lanez, whose legal name is Daystar Peterson, created a firestorm in the hip hop community, churning up issues including the reluctance of Black victims to speak to the police, gender politics in hip hop, online toxicity, protecting Black women, and the ramifications of misogyny or something like that, a particular brand of misogyny Black women experience. As such, there is no dispute that this public criminal trial of Mr. Lanez concerned issues of public concern. Along with this comes a panoply of views and opinions as is expected when celebrities are involved, which I agree. Speech by citizens on matters of public concern lies at the heart of the First Amendment, which was fashioned to assure unfettered interchange of ideas for the bringing about of political and social changes desired by peoples. It is clear from the allegations of the amended complaint that plaintiff takes issue with the opinions and statements made by the defendant regarding this trial. Evidently, the plaintiff believes that her narrative of events is undeniable and fails to realize that in trial, both sides cannot be correct, and rarely is there something that is absolutely true. I don't know about this one. And the reason why I say this is because, like, she blatantly said, when they talked about the weapon, oh, they lost the weapon. They lost the weapon. That was the whole purpose of Tory Lanez filing the writ of habeas corpus. And he did it twice under the assumption that the pow pow was missing. But that wasn't the case. Oh, it's about to hit hard. I saw that lightning come through the window. Good googly moogly. Yeah, so I don't know about this because yes, she was saying things, but I am thinking in regards to what she has put out in the universe as far as as the weapons and the things that she heard at trial, but she comes out and she's saying the opposite, knowing what the verdict was or knowing during trial. So I don't think that would actually fall up under an opinion and a statement when you actually knew what happened because you was at the trial and you heard everything. But let's continue. It is nonsensical to presume that in every case the losing side committed perjury or that the winning side told the truth. Criminal trials are essentially battles of narratives. Each side has versions of events they want a jury and public to believe, and they will do what they can to present evidence that matches up with that story. Juries and trial observers will then form their opinions regarding the credibility of witnesses, documentary, and physical evidence. Some observers may give credence to some witnesses and not to others. In a criminal trial, a group of individuals can view the same evidence and reach different conclusions, from justice was served on one end to this was a travesty of justice on the other hand. In the instant case of the five statements which plaintiff contends accused her of being a felonious perjurer, two statements were posted on X and three were posted from online streams. Plaintiff's allegations are at best disingenuous given that it was widely reported that plaintiff gave inconsistent statements to the police and given that she admitted on national television that she lied about her relationship with Lanez. The first purported statement that begins with "at the end of the day" was an excerpt from a December 21st, 2022 live stream. It is clear, let me see, wouldn't that mean that the state admitted to the Brady violation? That's what I gotta look at that. Right now, I'm on the fence. Right now, I'm on the fence. I'm on the fence on this one. It is clear that the complete statements that the defendant was discussing in an article published by NBC and then discussing her opinion and conclusions based on her observations of what happened at trial, including inconsistencies and credibility issues. She discussed witness testimonies, including that of Kelsey Harris and Sean Kelly, who themselves made suggestions that some of the witnesses were drunk at the night of the pow-powing. It is not surprisingly that the plaintiff did not quote the entire post because it undermines her claim. I get that, and I do get that part. So you never want to you have to put everything into context. The whole story. You can't just have them pieces. That's in anything. That's like when we're back in school when we were actually taking tests and you had to read the paragraph and you have to answer the question. You just can't read the question and then go to one part. You're gonna have to read it in its entirety to understand the context in which they were saying. Megan, 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 Megan. All right. Where was I at? What was I at? She is not surprising that the plaintiff did not quote that entire post because it undermines her claim. Nothing in this first 2022 post suggests that plaintiff committed the crime of perjury. It clearly is a pure opinion on a newsworthy matter. Hmm. Bec- if you believe one side, where's my water? If you believe one side over the other, and you express this view because you have doubts regarding a witness credibility at trial, this falls for short of accusing someone of committing the felony of perjury. Again, this is not something that can be proven as true or false because an individual's state of mind at a particular point in time is subject to empirical proof. The jury believed some witnesses and the observers, including the defendant, evidently believed other witnesses. The same thing can be said about the ex post referenced at paragraph 57, where the defendant is opining on what she believed was a botched investigation and credible witnesses. Okay, I give them that. That is her opinion. Again, simply suggesting someone was not credible is a far cry from saying they committed perjury. The suggestion by plaintiff is candid for it. If this were the case, then every losing party in a criminal or civil case would be persecuted for perjury. And that's correct. Mm. The Twitter post referenced at paragraph 60 also falls short of accusing the plaintiff of having committed a felony. It too constitutes pure opinion and rhetorical hyperbole, where the defendant is essentially finding fault with the prosecution of the case that Peterson pow pow Miss Pete because his ego was bruised. They cited Montgomery versus Risen, where it says assertion that the plaintiff was motivated out of greed or ambition was a subjective judgment, and calling the plaintiff a con artist and a fraud was non actionable opinion, because that is their opinion at the end of the day. Again, this is not a statement that can be proven as true or false, and further is not susceptible of any defamatory meaning towards plaintiff. So once again, by them calling her a drunk, slow, retarded, whatever terms, that is not really defamatory. That is just hyperbole, a rhetorical hyperbole. This the next statement where defendant says, "We know you align blank blank, and you have absolutely ruined Tory life." Again, plaintiff fails to include the entire post. Nevertheless, this is two is clearly opinion and rhetorical hyperbole. Also ignored by plaintiff is defendant's later statements in the post where she says, "Damn, you ain't a solid B in that regard. Then you lied on set. You just don't tell the truth." Again, it is undisputed by plaintiff's own words that she admitted in a television interview about her relationship with Lanes. The content appears to be streamed of personal opinions and reactions expressed in a confrontational tone. So, and that's what I was getting at. Is because the way that Milagro was expressing this on YouTube or in her tone, I guess it makes it seem as if it is defamatory and not, more so her opinions. So, at best, this statement is substantially true, and at worst, it's just pure opinion hyperbole, not defamation, as the law does not require perfect accuracy, only the publication be substantially true. That, boy, the law will get you. Hold on, let me see. Where was that at? I want to read the post. So, 5 is found in A2. Did I get A2? Hold up. Oh, I'm going crazy. Hold up. Oh, hold up, y'all, because I could have sworn I got the hold on, let me see. I want to see if I got the I could have sworn I pulled the freaking hold on. Let me do this right quick. Oh, I think they referencing back to what posted. It's found at Exhibit A2. Where's Exhibit A2? Let me see if I could just pull this up. Let me see. Hold on, y'all. Complete the post. Where is the final statement? Is another cherry pick line from a larger post. The complete August 7th post is found at A3. So what post what they're referring to is the transcript of the 22nd. I wish I could find that. Hold on, y'all. I'm gonna check somewhere else to see if I can. Did they even post exhibits? Mm, okay, let me see. Let me go to the appendix. Let me go to the. Oh, that's what happens when you don't actually read. Okay, so they said A2. Let's go to A2. So that's the YouTube transcript. Good googly moogly. All right. So A2, and that's A3. All right. So A2 says, I believe that this is exactly how they feel about you, Megan. I believe that this is exactly how they feel about you. We know you a lying blank blank and you have absolutely ruined Tori's life. Yeah, that's how they feel about you. Hmm. Then it says, I don't feel like they wouldn't have, wait, I don't feel like they wouldn't have you by they blank. And those are the things that make me feel like it won't ever go nowhere. Because at the end of the day, what brand? What's the cornerstones of Megan's brand at this point? You was supposed to be a girl's girl, but you are effing your girl's boy. You understand? You ain't no solid B in that regard. Then you lied on set. You just don't tell the truth. You stay in court. What was what has the brand become? The Tory Lanez victim who's trying to get up this deal that nobody cares enough to buy her out of? Like, child, what is this? Okay. Okay. Let me go back to where I was. All right. So that's part one. Wait, page 6. There we go. Now, Lord, I'm just losing my spot. All right, so this is where we was. All right. Then, and I read this post too. So it says the final statement is another cherry pick line from a larger post. The complete August 7th X post is found here at Exhibit A3. We're saying playing fast and playing fast and lose with the facts is precisely what the 11th Circuit criticized the plaintiff in the Turner case, and this is what the plaintiff is doing here. The full ex post reads, was Megan the Stallion caught trying to deceive the courts again? The answer is yes if you ask her former cameraman Emilio Garcia. After Emilio filed a lawsuit alleging an unstable work environment, MTS filed to dismiss the lawsuit brought against her with the potential to have the case refiled in New York. The thing is, Emilio is calling BS and says Megan is lying and lives in California. He has hotel receipts, tests, and emails. So the post then includes screenshot excerpts from Mr. Garcia's motion filed in the civil case and some exhibits. Again, this is clearly defendant's layperson assessment of the pleadings and allegations of a lawsuit involving a public celebrity and not susceptible a defamatory meaning as a common mind will understand them to be viewed in a full context. All right, that makes sense too. So this is what they're saying. So this is what was posted, but this is what, so they actually put up receipts, the filing. So she was referring to a filing. Yeah, because I think she only posted this part. I didn't see none of this. So yeah, that's right there. That's an opinion. See, Megan, chow, 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 chow. Again, plaintiff's testimony at trial cannot be proven true and false given the different narrative. The fact that the jury convicted Mr. Lanes does not necessarily mean that plaintiff's testimony was infallible and an absolute truth. Rather, that is what a jury chooses to believe. A different jury may reach a different conclusion, hence why the statement is opinion and not defamation. That is true because all they're doing is they're basing it on the facts. Whatever they discussed in that verdict room, in that trial, well, jury room, that is what it was. But if you get a whole nother set of jurors, they're going to have a different opinion. So I see the correlation. The next set of statements, that paragraph, they're picking apart every statement that Megan has included in her complaint that she believes is defamatory. The next set of statements, at paragraph 64 and 95, purportedly live streamed and posted on X as described in the amended complaint, are once again cherry picked lines clothed in plaintiff's self serving innuendos while ignoring the full context of the post. A complete copy of the January 29th, 2024 X post is found as Exhibit 4. So, all right. So here, wait, this is all exhibits. Why does she look like, is that Niecy Nash? Why does that look like Niecy Nash? Oh, she posted that. Gotcha. Oh, man. So that was all part of that. So she was talking about this was that was her opinion about what was posted, the lawsuit with the cameraman. Okay. All right. So here's exhibit A4, which is the whole post. So she attached, let me see, let me go from this receipt of Megan's ex bestie telling me she wasn't effing T Ferris. That's her guardian. Oh wow. That's the actual post. And it reads, okay, so back in 2020, I'm doing what I do now, and a rumor was circulating that MTS was FNT Ferris. I reported on it, and since old girl and her friend's family watched my show, one of her besties that I had an internet rapport with hit me. As you can see, she said it wasn't possible for MTS to be sleeping with T Ferris because he was like a father figure. I thought the verbiage was odd, but at this time I went on and I realized MTS was slow and needed one, so it made all the sense then. I covered this case from the moment it happened, and my IG was targeted, which resulted in me losing conversations. Good thing I recorded everything and put it aside. Lord, Lord, Lord. All right, so that was Exhibit 4. So this post does not suggest, as alleged, that plaintiff was engaged in a relationship with her manager, T. Ferris. To the contrary, the post suggests that the exact opposite, and it does once you read it. It really does once you read it. As far as the statement made by defendant that she believes Miss Pete was slow because someone told her that Miss Pete needed a guardian is not defamatory per se. Actually, plaintiff is suggesting that insulting someone by calling them slow or retarded somehow rises to the level of defamation. In reality, those words constitute rhetorical hyperbole. Whether the language is hyperbolic is relevant to distinguishing fact from opinion. Rhetorical hyperbole is language that, in context, was obviously understood as an exaggeration rather than a statement of literal fact. Is not actionable. So if you tell now, I get that here. Sometimes when somebody might forget to do something, be like, "Oh, you slow." You're saying it rhetorically. You're not actually saying that they're slow, unless you actually, that's one thing. That's one thing. So I get it. So Megan took it as she was calling her slow, actually slow. Um, but as they stated here, per the law, it was rhetorical hyperbole. It was pure exaggeration. Unless you're gonna sit there and make it a fact. Oh man. In particular, the ad hominem nature of abusive epithets, wow, whoa, vulgarities and profanities, which some writers and speakers use to enliven their prose, especially in the hip hop universe. As noted by the 11th Circuit, name calling, however inconsiderate, is not false. Statements that plaintiff was stupider and crazy constitute opinion and thus cannot be proven facts. Unless you take a test and that's something, I'm gonna just keep that to myself. Um, let's see. Further, courts have held that referring to someone as an idiot, raving idiot, idiots, and more vulgar variants were rude statements of opinion rather than lay diagnosis of mental capacity. Similarly, courts have held that statements calling the plaintiff stupid, a moron, or a nincompoop were not actionable. A nincompoop, I've never heard that. Courts have also held that the statements potentially referring to a plaintiff's mental health, such as a raving maniac, a pitiable lunatic, wacko, nut job, and hysterical, crazy, and crank, were statements of opinion. As to the third statement, where defendant states, "What is Megan's mental status? Does she have a guardian or not? Or has she listed as a capable person? Has she ever been deemed legally retarded? Like anything of the nature? Anything of the sort?" This type of statement, by its very nature, is a speculative opinion that cannot form the basis of defamation action, as they are not statements of facts. Ooh. All right. So here they give an example. They cited Turner versus Wells. So this is what it reads. At night, I'm sitting in a dark room thinking, probably why I always end up drinking. Yes, I'm very depressed. How can somebody so blessed want to slit their wrists? Ish. I probably bleed out some Hanoi. I don't know what that is. Is it a drink? Probably some wine. When they find me, I'm I'm in Valentino A. He pouring me shots, thinking it's lit. Ha! Little did he know. What in the world? Where is this? Oh, that is her Cobra song. Child. What? Hold up. Because that went straight to 7. That went straight to 7. Footnote 7. Plaintiff suggests that the November 3rd, 2024 statements by defendant at boy, the fact that they sat there and quoted her freaking song is crazy. Plaintiff suggesting that the November 3rd, 2024 statements by defendant at paragraph 98 referring to plaintiff's drinking as defamatory is nonsensical, as they are too as they too are pure opinion and rhetorical hyperbole by the nature to wit. You ought to be somewhere with your alleged crimes, drunkie. Why do you even speak? Like, does your liver even function well? Or when you have drinking seemingly running through a family. Yes, I did post certain questions to my page. Yes, I did. And then the third part, Miss Pete comes from a family of alcoholics. Because the fact of the matter is, you have a father that was an alcoholic. Your daddy, was your dad on drugs, or was he in and out of the system? Was what was what was that for? Do you want to talk about that? Is stealing worse than drugs or ish? Given the parameters of Rule 11, it seems quite preserved that the performing artist, with her own tequila brand and who routinely raps about heavy drinking, such as in her hit song Cobra, and who's a drunken video of herself online, boy, this just gets worse, would somehow suggest that the above comments were defamatory. In fact, in her recent documentary, Miss Pete states that she was getting lit to get her through her pain, and I wasn't no bad person, but I was definitely drinking like a MFer, though. But I wasn't fighting. The worst thing I was doing was drinking and ucking. That's it. Good grief. Nevertheless, as with the other comments complained on of in the amended complaint, these statements are particularly true opinion and hyperbole. Ha! They cited Demoya versus Walsh, where under the substantial truth doctrine, a statement does not have to be perfectly accurate if the gist or sting of the statement is true. Ooh, Lord Jesus. Lord. Further, these comments pale to the utter in Orsley versus Rivera, where the court held the statements made by a television host that an anti abortion activist online post made him an accomplice to homicide in the unaliving of a doctor who performed abortions was rhetorical hyperbole, as the host words were used to convey the view that the plaintiff was morally responsible for the doctor's unaliving and thus was protected by the First Amendment. Oh my gosh. Oh my gosh. Blase, 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 blase. Let me see. Notwithstanding that the plaintiff's amended complaint fails to show that any of the statements made by the defendant constitute anything more than pure opinion and hyperbole, further sinking her claims in the fact that she also fails to establish malice by clear and convincing evidence. In fact, plaintiff treats this claim as it were one brought by a private individual as evidenced by the negligence standard cited in paragraph 103. Moreover, a failure to investigate or publishing, even when a reasonably prudent person would have done so, is not sufficient to establish reckless disregard. They cited a couple of cases, and it says, as noted by the 11th Circuit, in defamation cases, there is a powerful interest in ensuring that free speech is not unduly burdened by the necessity of defending against expensive yet groundless litigation. Indeed, the actual malice standard was designed to allow publishers the breathing space needed to ensure robust reporting on public figures and events, forcing publishers to defend inappropriate suits through expensive discovery proceedings in all cases would constrict the breathing space in exactly the manner the actual malice standard was intended to prevent. Excuse me. The costs and efforts required to defend a lawsuit through the stage could chill free speech nearly as effectively as the absence of actual malice standard altogether. So Megan didn't, well, her attorneys review these transcripts and these Twitter posts in this entire. Mm. There is no showing anywhere in the amended complaint by clear and convincing evidence that the defendant purposely avoided further investigation with the intent to avoid the truth. Further allegations of spite and ill will on behalf of the defendant is not enough to establish malice, and neither is the defendant's motive. At best, while plaintiff can show spite between the defendant and her, this is not enough to establish malice. With respect to defendant's statements on about how the Lane's trial was conducted, this too amounts to much ado about nothing, as the full context of the post shows that the defendant relied on courtroom pleadings and documents, police reports, and her observations while attending the trial to support her opinions. So, because remember, these are all her opinions. I'm just still stuck on, and I get everything that they're saying. However, it's just one part about the pow pow. You stated that the pow pow was lost, and that was one of the. So I get everything else is her opinion, because that's pretty much what I'm doing, and any other content creator who reads court docs. We read it, we give our opinion, and I get that. However, I'm still stuck on the fact about the pow pow. And I wonder if they're going to reference that in here. While defendant's statements may not agree with the narrative preferred by plaintiff, she needs to understand the best response to speech you do not agree with is more speech, translation of opinions or ideas one disagrees with. Under the First Amendment, there is no such thing as a false idea. However, pernicious an opinion may seem, we depend for what its corrections not on the conscience of judges and juries, but of the competition of their ideas. Hey, what's up, Buttercup? Yeah, and that's the thing. I have to see the document, because I don't see the document, and I'm not going to go over. How can I say this? If you're not posting a declaration or a an affidavit that is notarized, I'm not going to believe it. And the only reason why I say this, anytime we get any type of document that I request, um they have to verify the true and accuracy of that. So just like the state did, in where um because when Tory Lane submitted his writ of habeas corpus, that was the whole purpose. His purpose of filing that is because he was thinking that the pow pow was missing, but it has came and it was like verified by the LAPD property and evidence supervisor, whoever the head of that department, that it has always been with LAPD. So I'm trying to figure out, I need to see what document was posted, because if it's not coming from the people that are in charge of the evidence room, that's not valid. That's not valid at all. Oh, she just don't give up, huh? And she don't. It's on Unite the People IG. Hold on, I gotta see this. Yeah, because if it's not coming from the place that actually has the pow pow, I'm not believing anybody. That's just like somebody telling me about somebody else's medical records. I'm not trusting your word. I'm going straight to the source, and I am going to get a true and correct accurate copy of those medical records and read them myself. Um let me see. Unite the People. That's one thing I got to say, because they did, the state submitted that. Let me see. Ba, 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 ba. Oh, I don't even know how far back to go. I want to know, somebody send it to me, because I guess I have to do this off of here, because I want to know what, how, and what. And that was my question in the last live that I had. How can I say this? If you want to support your writ of habeas, you support documentation, tangible documentation. You're stating that the pow pow was missing. So just like the state went to the LAPD evidence room and they got a signed declaration from the person that oversees all of that, that was their support for their response to his habeas corpus. So, where is the supporting documentation from the defense counsel that shows that the pow pow was missing? Okay, well, I have to go back and read that. If you read the writ, it shows how the state lied during trial. Okay, what in the world? I do not want to do a loan signing today because, child, it's raining outside. Hold up, let me respond to this. Nope, I ain't doing that. All right, I have to go through the habeas corpus because I did read that. But here is the thing though. You have to provide proof. So the state lied where I have to look through it. I'm gonna look through it and I'm gonna reread it and I'm going to see what supporting documentation the defense counsel provided to show that the state lied. Cause that's all I'm about. I have to have tangible evidence. I have to have something to reference. So if you say that it's a lie, you have to show proof that it's a lie. That's the whole purpose. When we go through trial and we getting ready for trial, we have a whole probably 5, 6, 7, 10 binders full of evidence that we are going to provide, supporting documentation to support our side. Same thing, everybody. So if I want to catch you in a lie, I better have some proof of that lie. So I'm gonna go back and I'm gonna reread that of habeas corpus and see if they actually, because even though they can say that the state lied during trial, but what evidence do you have to say to support that they are lying? Just the same way the state had supporting documentation saying that the gun has well, the pow pow has always been with the LAPD. Call it, the same has to happen with the defense counsel. They got to prove their case. Let me see. Where am I at? First thing the defendant could be accused of here is using colorful language to criticize the plaintiff, other trial witnesses in the trial itself. While plaintiff may seem entitled to a higher sense of privilege due to her fame, prestige, and finances, she does not own a monopoly on the truth or to any particular narrative. As count one of plaintiff's amendment complaint is replete with nothing more than mostly irrelevant and conclusionary allegations buttressed by unwarranted innuendo, speculation, and self serving deductions as a whole when viewing all of the complaint of statements in their full context. It is evident that plaintiff has failed to plausibly allege that any of the defendant's statements were substantially and materially false, published with the requisite malice so as to state a claim for defamation against a public figure. So all of that to say that count one should. Okay, so their expert said on the stand that all was missing. Okay, I'm going to look. I'm gonna dig because I didn't follow the trial, so I'm just basing off what I have seen thus far. So I'm gonna go back and I'm going to read that transcript so I can pretty much catch up. All right, so let's see. Count two fails to state a claim. Oh, now they're talking about the video. How many Oh, we about to get through this quick. So count two fails to state a claim for the violation of this. So blah 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 blah. In count two of the amended complaint, plaintiff once again submits nothing but conclusionary and fallacious allegations that the defendant promoted a deep fake video of the plaintiff based solely on the defendant's purported liking a third party posting of the video discussing that this came to her attention and then in order that her listeners knew that she was discussing by posting on X. Go to my the suggestion by plaintiff that defendant's actions constitute a violation of the statute. It undermines plaintiff's own allegation that in this same post, the herself told the public that the video appeared to be a deep fake and that the plaintiff should sue the individuals who made that. See, I didn't even know that part. Plaintiff is a public figure, and the defendant's live discussing about this video and ultimately debunking the video as fake. Plaintiff somehow believes that the defendant's action constitutes the promotion of the video as so as to trigger the statute, civil and criminal penalties. The right was posted October 7th. If that helped you, thank you. The writ, gotcha. So the October 27th one. All right, go find that. Thank you. All right. So, and this I always say about making sure that you read everything in its entirety. So this makes sense. So the girl even said that she should sue whoever made that. Okay. I give her the benefit of doubt. So anything that she said about this is merely her opinion. I get it. I get it. In addition to its specific criminal penalties, Florida statutes provide civil remedy, injunction relief, actual damages of $10,000, whichever is greater. All right, I ain't gonna go into all this. To state a cause of action pursuant to the statute, plaintiff must establish the following: the defendant willfully and maliciously promoted and altered depiction of an identifiable person. 2, without the consent of the identifiable person depicted. 3, that at the time the defendant knew or reasonably should have known the depiction was an altered actual depiction, in which she did say that Megan needs to sue whoever did this because it was false. Yeah. Under the statute, promote is defined as follows. Promote means to issue, sell, give, provide, lend, mail, deliver, transfer, transmit, transmute, publish, distribute, circulate, decimate, present, exhibit, send, post, share, or advertise, or offer, or agree to do the same. Now, here's my thing, because now, I mean, she did say go like the video, and she did. I'm on the fence about that one. Yeah, she did say that Megan should go sue whoever made it, and that's her recognizing that it is a fake video. But on the same token, you gonna tell people to like the post? Given that this court must strictly construe the statute, it is evidently clear that the plaintiff's amended complaint is suggesting that this court apply a rather liberal construction, ignoring the plain meaning of the statute of definition of promote. Notably absent from the statute's definition is the term discuss or mention, which is precisely what the plaintiff is suggesting. Using the plaintiff's circular reasoning, anyone who speaks or make mention of the existence of such a video is liable under the statute regardless of the circumstances. Interestingly, the amended complaint also alleges that the above allegations were reported in a news publication, Uproarks, don't know how to say that, which evidently found that the matter newsworthy and itself linked to the same video. Then it alleged that the defendant made the following statements on a post: whoever follows me. Oh, she said go to my likes. Okay. Thank you for that clarification. All right. So she didn't say go like my post. She said go to my likes in order to find the video. Okay. Then it alleged that the defendants made the following statements on a whoever follows me on social media. I'm about to read it right here. Whoever follows me on social media, go to my likes to see what is that we're discussing. All right. So the amended complaint then alleges that the defendant then published a video entitled Milagro Gramz officially responds to claims of a lawsuit and harassment against Megan Thee Stallion on YouTube, where she addressed go to my likes X post related to the deepfake video, where in the YouTube post she questioned Wheat is a professional victim. Notably, the plaintiff concedes that on June 8, 2024, defendant did in fact question the authenticity, authentic, authenticity of the video and occur. Y'all, when you get to reading documents all day, I don't read them out loud. I read them in my head. So just bear with me. Of the video and encourage plaintiff to sue the person who made it. With the way deepfake and AI be going these days, if it's not her, she should sue whoever made it. That ish dry as to do. Okay. All right. So I get that. So I understand why they are debacling in that. See, I did not know all of that. So that makes sense. So she really uh she didn't make the video. She didn't say go to my likes or anything. She didn't promote it. She didn't do anything, any of that nature. She just directed people to go to her likes to see what it was that they were discussing. It is undisputed from the amended complaint allegations and the cited links to the online publications that the defendant did not create the video, nor did she repost or share the video on her social media or any media. Despite the particular spin that the plaintiff wishes to put on the facts, the reality is that the plaintiff is suggesting that if someone refers or speaks about the existence of a deepfake video or presses the like button on a video, that it constitutes the promotion of a video. And by law, it does not. Such an overbroad reading from would run afoul of the First and 14th Amendments. All that is alleged in the lawsuit is that one, the defendant liked the video, which had been previously posted in an online public forum, which already had over 51,000 views. Exhibit. Let me hold it because I've never seen this. Oh, they have the transcript, baby. Oh, an AI generated circulating online web while Megan Thee Stallion's hot girl is smashing records. Okay. So this is the transcript to the YouTube that she made. That makes sense. Defendant later posted a tweet saying go to my likes so people could see what she was discussing, which she later deleted. And 3, defendant later published a YouTube video where she discussed the uproar article and questioned whether plaintiff, a worldwide celebrity with millions of fans, was a professional victim. Who's to say that Upwork's article garnered more attention to the video than the defendant who simply stated go to my likes? That's true. In fact, the media site Uproar, I don't even know if I'm saying it right, but who cares at this point, and linking to the purported video would on it worse than what the defendant did, as she did not link to the video in her post, nor did she post it on any of her platforms. Plaintiff argument that the above is a violation of the statute is, oh yeah, gracious and frivolous. I get it. I agree. I have agreed with everything the defense counsel has said thus far. Blah, 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 blah. The statute definition at that particular section requires that the violating party actually create and put the offending video into circulation, or that they provided a copy of the offending video to someone, or that they posted online, or that they provide a copy of the video in exchange for remuneration. Anything beyond that begins to trample onto First Amendment and due process territory. So all she told people to do was go to her likes and see what they were discussing. She didn't share it. She didn't repost it. She didn't redistribute it. She didn't do anything. She wasn't even the one who put the video out there. In any event, there is no factual allegation that the defendant procured, manufactured, issued, or sold the video. Neither is there any allegation that the defendant provided a copy of the video to anyone. The amended complaint is also devoid of any factual allegations that the defendant broadcast or transmitted the video, transmuted it, or published it, or posted or exhibited it in any form. Nor is there any allegations that the defendant advertised the video for purposes of promoting sales of the video. nor is there any allegations that the defendant represented this online video was in fact the plaintiff. To the contrary, it is undisputed that the defendant indicated that it was not the plaintiff and that the plaintiff should sue whoever made the video and posted it online. There are no factual allegations that defendant shared or disseminated the video to anyone. As such, count 2 of the amended complaint does not allege any facts that plausibly state a cause of action under Section 836.13. If anything, the promotion of the alleged deepfake video was perpetrated by the unknown individual who published and posted it online, not the defendant. So they're asking for that count to be dismissed. Remember, she was talking about the intentional infliction of emotional distress. So it's this one, and then the last one is the cyberstalking. I really want to see what that one says. Once again, count 3 attempts to state a claim for intentional infliction of emotional distress based primarily on online commentary and opinions. Because at this point, they have already said these are opinions, these are rhetorical hyperboles. Nothing is defamatory. So therefore, you can't be sitting up here claiming that you're emotionally distressed due to simple opinions. Blah, 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 blah. Let me just reread that. Once again, count 3 attempts to state a claim for intentional infliction of emotional distress based primarily on online commentary and opinions made by the defendant regarding the highly publicized trial of Laboratory Lanes. However, the amendments to the complaint do not rescue this court from dismissal under Florida law. Taking into consideration the allegations that the defendant pressed the like button on an unknown third-party social media post purported to depict a deepfake video of the plaintiff, or defendant's online comments about the Lane's criminal trial, or the commentary about the plaintiff's drinking, because at this point she done put it in songs. They got a video on her. That's yeah. Or calling the plaintiff retarded, or calling the plaintiff an angry black woman, or all of the above. These allegations fall far short of stating a plausible claim for intentional infliction of emotional distress under Florida law. Not surprising, none of the facts in the amended complaint that the defendant committed any acts of violence against plaintiff. There are no allegations of assault or battery or false imprisonment or of any similar threats. The perceived wrongs in this case are based on mere words and opinions regarding a public figure, a high profile trial, all of which are protected by the First Amendment. If the First Amendment can protect real despicable conduct, such as what is described in Snyder and Phelps, which reversed the intentional infliction of emotional distress verdict against protesters at a funeral of slain Marine holding signs of messages such as God hates. Oh, I'm not going to say that. Thank God for IEDs and America is doomed. And bad as that sounds, as bad as that sounds, I'm pretty sure they're saying those are those folks' opinions and they are protected by the First Amendment. Then surely defendants' words and opinions, which pale in comparison, are protected as well. So they're saying if people can be out there protesting and holding signs of that nature and they're protected under the First Amendment, then everything that Milagro Gramz have said is protected under the First Amendment. Under Florida law, a plaintiff must plead the following elements in order to state a claim for intentional infliction of emotional distress. One, she has to plead that the conduct is extreme and outrageous, an intent to cause or reckless disregard to the probability of causing emotional distress, severe emotional distress suffered by the plaintiff, and that the conduct complained of caused the plaintiff severe emotional distress. Under the first prong, conduct must be so outrageous in character and so extreme in degree as to go beyond all bounds of decency and to be regarded as atrocious and utterly intolerable in the civilized community. And I really don't have to go any further because I can sum this up for y'all. If it, this right here, this is bad. This right here, really bad. A slain Marine died, right? And they put thank God for IEDs. And that language, all of that they said was considered protected under the First Amendment. And if we compare that to what, Milagro's opinion was in her YouTube videos, on her Twitter posts, it's far from this. Fortunately, yes, words hurt. Words hurt, and words can lead people to do, bad things to themselves. But if you have this and they're comparing it, and that's nothing compared to what she said, I don't see it. So Megan's claim in regards to what all was said, it, it's no worse than this. And this is protected by the First Amendment. So by that says, her amended complaint really does not and like it says, the amended complaint, all the support for that particular cause of action falls short. She doesn't state a claim for the infliction of emotional distress. Let me see. And look, holding in sexual harassment case that allegations of repeatedly touching, squeezing, fondling, hugging, blowing, tickling of the plaintiff, along with the reputation of lewd and vulgar remarks, precluded the dismissals of plaintiff complaint at a motion to dismiss. Yeah, I don't think that Megan has a strong claim for intentional emotional distress when you go back to look at the things that were said, and those things are just opinion, rhetorical, hyperbole. All of that is protected by the First Amendment. So I can see it ain't looking good. I mean, as I'm reading, I promise y'all it ain't looking good. Now, this is what I want to get into. The cyberstalking. Count 4 of the complaint purports to bring a claim for injunctive relief for cyberstalking pursuant to Section 784.0485 of the Florida statute. As this claim does not provide for an award of damages and seeks only injunctive relief, presumably, plaintiff is attempting to bring this action by invoking this court's supplemental jurisdiction pursuant to Title 28 of the United States Code, Section 1367. In order to be entitled to an injunction for cyberstalking, the court must apply a reasonable person standard, not a subjective standard, to determine whether an incident causes substantial emotional distress. In Lowe versus Book, that citation, it says, and there must be no legitimate purposes for conduct. Further, injunctions are not available to stop someone from uttering insults or falsehoods. Because if that was the case, then everybody out here would, have an injunction to stop people talking about them. The First Amendment prohibits such restraints through the use of injunction relief. As there are no allegations that the defendant made any direct threats of violence or other allegations that fall within the statutory definition of cyberstalking. Count 4 should be dismissed on the merits with prejudice, meaning that she cannot come back and ask for another injunction for cyberstalking. Secondly, count 4 should be dismissed for plaintiff's failure to follow the mandatory statute requirements set forth. Specifically, the statute requires that the petition be verified under Florida Statute Section 92.525. Plaintiff has attempted to cure this problem from the initial complaint by filing what purports to be a sworn petition. However, with respect to facts supporting the petition, Section D, she merely states in a circular manner, petitioner is a victim of cyberstalking because respondent has committed cyberstalking. She didn't go into depth on how or describe how she cyberstalked her. Let me see. Now she provided a description, but I don't think those descriptions really wasn't descriptions. I'm gonna be honest with y'all. Nowhere does the plaintiff verify that the allegations of the amended complaint are true under penalty of perjury, as one would do in a verified pleading. She merely avers that the facts are described in her amended complaint. The statute clearly states that the facts supporting the petition must be sworn to. As the factual allegations supporting count 4 are not under oath, they fail to comply with the statutory requirements outlined in Section 3. So, pretty much, she didn't even provide any type of affidavit to go with her injunction relief. She did not, she really didn't describe the facts in regards to cyberstalkers, like how specifically, how is she stalking you online? All she did was said the facts are outlined in the amended complaint, and she didn't say it, her attorney. They need to do a little bit better job with that. So the attorney did not elaborate, they just reference the defendant back to the amended complaint. The statute clearly states that the facts supporting the petition must be sworn in, or I think I already read that. As the factual allegations supporting count 4 are not under oath, they fail to comply with the statutory requirements outlined in the section. Yeah, in the event that the court deems DE 28-1 complies with the statute and that the court states a plausible claim, then defendant once again respectfully requests that the court decline to exercise supplemental jurisdiction over count 4. Oh my goodness, this is long. What they stated in Cassandra versus Harvey, noting doubts that the Florida legislature intended that claims under this section would be litigated in federal court because the injunction contemplated by the statute of akin to a domestic injunction, that the state court judges who regularly presides over injunction dockets are better suited to handle on the expedited timeframes in the statute. In a subsequent decision on the same judge, Judge Weatherwell noted that while a federal court could theoretically exercise supplemental jurisdiction, however, upon further reflection, he found that there appeared to be compelling reasons for declining jurisdiction. As this case is in its early stages, given the well-reasoned opinion by Judge Weatherwell on the exact same issue in Kassenhoff 2, in the event the court does not rule on the insufficiency of count 4, she hasn't provided any type of proof, or it hasn't been verified. Let's start with that. It hasn't even been verified or sworn, or even a declarations that says, then this court should decline supplemental jurisdiction over the claim pursuant to Title 28 of USC. If the plaintiff wishes to obtain an injunction under that section, she can refile the Circuit Court of Miami-Dade and testify in person and prove her case accordingly before a circuit judge. So they're saying that the federal court will not have jurisdiction. So she would actually have to file it under the circuit court if she wants to go ahead and you know what, that is interesting, because just like the restraining order, she went through the county court in California. But I see where the attorney is going with this, as far as her attorney, when he did file it the injunction in federal court, because if you're thinking it's over the internet. Plaintiff claims for attorney fees. Oh yeah, she did ask for attorney fees. They're saying, "Nah, we ain't about to pay no attorney fees." Counts one, two, three. So counts 1, 3, and 4 of the amended complaint, the plaintiff is seeking attorney's fees. It is well settled that under Florida law, each party generally bear its own attorney fees unless a contract or statute provide. Florida has some weird laws. I'm not gonna lie to y'all. Counts 1 and 3 are intentional torts, and count 4 is for an injunction under statute that does not provide the recovery of attorney fees. So they're saying dismiss it. We ain't paying. She gonna pay for her own fees. Good googly. I'm gonna read this last part. Here's the conclusion. So this whoever's helping her out, they're pretty good. And mind you guys that you see how detailed this is. Megan did ask for an extension to be able to reply to this, in which she has the right to. I'm very interested to see what reply Megan's attorney is going to provide, because this right here, I'm just like, I don't know. This was a good one. This was a really, really good one. So, in conclusion, in 1975, Nobel Prize winning songwriter and artist Bob Dylan wrote and recorded a successful song called Hurricane, which depicted the unaliving trial of prize fighter Reuben Hurricane Carter. And then it cites Valentine versus CBS Inc. And then it says the song went on to describe the unfairness and racial undertones of the trial and portrayed a perceived conspiracy between Bello Bradley and the police to unjustly convict Carter. Taking Miss Pete's logic and bringing this case to its ultimate conclusion, given that a jury convicted Carter, any individual who's suggesting something to be contrary or who criticized the credibility of the state's witnesses in the trial should be guilty of defamation. Patty Valentine, who was mentioned by name in the Dylan song, thought as Miss Pete did and sued for defamation, claiming the song implied that she was involved in conspiracy against Carter. Both the district court and 11th Circuit disagreed. If Miss Pete's mindset had been applied back in 1970s, then the Bob Dylan classic song should not have been published or recorded, and perhaps Reuben Carter would have died in prison or unalived in prison, or I should say deceased, that's better, in prison, and the world would not have been able to enjoy the Bob Dylan classic recording. Defendant's First Amendment complaint does little to revive their dubious claims and legal theories into plausible causes of actions. Accordingly, for the reasons set forth herein, defendant requests that her motion to dismiss the First Amendment complaint be granted, and the court awarded defendant attorney fees pursuant to that under that Florida statute. And that's it. I'm really on the fence on this one. I mean, they did put out some. I'm not going through all of that. All right, so this is Megan's. Before I'll go on to what I want to say, this is Megan's motion for an extension to respond to the motion to dismiss, and that's the proposed order. That's that. Okay. Now, I'm all for the law. I'm all for the law. That was a very good response. Response to the First Amendment complaint. That was a very good one. And I do get everything that was listed for each count. I do get that. I do get it. Here's how America works. I don't know if y'all are aware, but Trump had a essay lawsuit. I forgot what the individual's name, where he groped her and all this other stuff, right? And they ended up Was that the I don't think was that the falsifier man? It's so many cases this man has out, okay? ABC did a segment. I don't know if it was a segment, if it was an interview. I don't know what it was, but they talked bad about Donald Trump. Donald Trump sued ABC for defamation, right? Now, we just went through this whole lawsuit about people's opinions, the level of opinions, rhetorical, hyperboles, exaggerations, and we seen them cite a case where a marine was slain in the protests and what that language was, and it's not from comparing Megan's case to the marine. I feel like the language for the marine at that protest was bad enough, but that even was protected by the First Amendment. So I go on to say that Trump actually won that defamation suit. ABC has to pay, well, they can't pay Donald Trump because he's president elect. So they would have to submit that 15, is it 15 million that they got to pay this man? And they're going to donate it to a charity. So, and I'm going to pull that case because I want to know exactly what is said. And I know it's, well, you know what? Because he's in Mar-a-Lago. So I wonder if he filed in Florida. I have to pull that case because I want to know exactly what was said and how he won that lawsuit. Because I was like, wouldn't the rules still apply just like in Megan Pete's case? And I get it. Everything that Milagro said was, an opinion. And she did, or I don't want to say she, her attorney only took out certain facts or certain lines from the whole context. And so me personally, that's how I was basing my opinion off of what was in the pleadings, not knowing that it's a whole post that goes behind it. So that is why I am on the fence here. It's different jurisdictions, unfortunately. Every court, every judge has their own decision and opinion about this. But I'm just trying to figure out what would be the difference between Megan's case and Donald Trump's case. Besides, I mean, they both got money, but Donald Trump is richer. But what would be the difference? Why would it be, I don't want to say okay, but why? Because I'm honestly, the way that this defense counsel did this opposition, I'm leaning towards they might dismiss her case. I'm just saying. But if we take a look at Trump case, his case wasn't dismissed. And people are about to pay a charity 15 million because he won a defamation suit. That's my thoughts. What are y'all thoughts? Definitely put them in the comments below. This is okay. Oh, there we go. Lana Davis said he. Okay, so that's what it is. So they said that he did something that he didn't do. They said that he did something that he didn't do. He wasn't convicted of it. But see here that okay, so listen, that is crazy. Nothing really said it was false. But that's the thing right there. So they said it. That was okay. How can I say this? They said it, but they didn't have any actual facts. So Trump won that. I gotta sit there and I gotta take notes on both cases. I gotta look at this man's case and I gotta relook at Megan's case. because I'm just looking at the complaint, what was said, and I have to look at the ABC, whatever they did on Trump to see exactly, because one like I can't take what you said. Now I know you said that they said that he raped Jean Carroll. Um, oh, that Midas Touch. I gotta go back over there and listen to them again because they was actually talking about that. But you know how many things that uh Trump has been accused of? How I done found so many lawsuits, him and freaking Epstein. This is disgusting. Man, this is crazy. Nothing really said was false. They asserted it as a fact. Okay, gotcha. Like how Milagro keeps saying Tory is innocent, but he was convicted. Yeah, this is who, yeah, the law is so complicated. And that is why we have judges to interpret it, to interpret the law. So they're going to look at the case and they're going to interpret and apply it as they see fit. But this is some good stuff. Not saying it's a good situation, but it's some good stuff to kind of look into because it gives you, help your brain learn some critical thinking skills. But yeah, but y'all definitely tell me what y'all think about this. Do y'all think that Megan's case will possibly be dismissed? Because I'm not going to lie, defense counsel came in hard, strong. They addressed every single count, causes of action in that amended complaint, and they cited some very reputable and strong cases. So they're giving, hopefully the court can give Megan's lawyers the opportunity to get an extension so that way they can apply, they can do their researches, cite their cases to support their causes of action as to why they put what they put in the amended complaint. So I'm very excited to see what they're going to come back with. But y'all let me know what y'all think about it in the comments below. Thank y'all for tuning in. We've been in for about an hour and 42 minutes. I'm done for today. I'm about to go enjoy this rain and get ready for Christmas tomorrow. But thank y'all for coming over here. Please don't forget to like the live. Don't forget to share and subscribe. Definitely comment. That helps me out so much. Until then, you guys have an awesome, blessed, and safe Christmas Eve and holiday, as well as Christmas. And I will see you guys on the other, what? Until then, I ain't gonna say on the other side because I don't know where I'm going. But I will tune in with y'all after Christmas, okay? All right. Thank y'all for tuning in. Y'all stay blessed. Bye.